Hey, what's going on, guys? So, I have before me the Federal Rules of Criminal Procedure, and this version is from December 1st, 2017. I actually read over, or a couple of days ago, I read over the version for December of 2014, and I just realized that there's an up to date version of this. So, I'm going to go over the up to date version of the Federal Rules of Criminal Procedure as it pertains to the end game, right? In any criminal trial in the federal district, there's going to be post judgments. And I thought it'd be really nice to create a video that talks about post judgment and look at some of the things that happen in post judgment, and also look at some of the options for defendants in post judgment trials, right? So, post judgment can also be called the end game. In my opinion, what happens is that when the defendant is in court, in federal court, he or she may get a verdict against them, but it's not really over. It's not over yet, right? So there's quite a bit that can happen in the end game. And I think that if I was a defendant and I got a judgment against me, I would probably immediately lose hope, and I'd throw my hands up in the air and just not even want to participate in the process. But the reason I'm going over this video is to show you that that's not a wise move. That's not the best approach, right? Okay, so we're going to look at Title VII post conviction procedures. So I'm going to title this video Title VII post conviction procedures. And again, this is going to be looking at the end game of what happens or what the process is when a defendant in federal court loses. And again, most defendants probably lose all hope at the point that they're convicted, and they may just throw their hands up. But in this video, I'm going to show you why a defendant shouldn't lose hope, because there's quite a bit that goes on. You can mitigate your loss. So maybe you did get convicted and you're losing, but you want to reduce the amount of damage that loss is going to impact you, or you're going to reduce the amount of damage that loss is going to take from you, right? Or you could essentially try to reverse your situation. Perhaps you want to ask for a retrial, or perhaps the defendant may want to appeal. So there's lots that goes on, but without further ado, let me just try to quickly get over to this section section 30, Rule 32, which talks about post-judgment procedures, right? Okay, so here we are. Post-conviction procedures, Title 7, post-judgment conviction procedures, right? So essentially, Rule 32 in the Federal Rule of Criminal Procedure talks about the post-judgment conviction procedures. And the first part of this, it talks about sentencing and judgment. And it just goes, in general, the court imposes sentence without unnecessary delay. However, the court may, for good cause, change any time limits prescribed in this rule, right? So under normal circumstances, they're just going to lock you up right away. If you're a defendant in a federal trial, they lock that defendant up right away. But there could be reasons for delaying or changing the time frame on when the defendant gets locked up. For example, maybe the defendant may want to appeal and he wants to talk about bail pending appeal. That would be a justification in my mind. I could be reading this wrong, but in my mind, the things that I can think of is appeal, and there could be other reasons why the court may, for good cause, change any time limits prescribed in this title, right? So anytime you lose or anytime a defendant loses in federal court, there's going to be a pre-sentencing investigation. And I am going to just kind of speed through this as much as possible. But what happens, and this is pretty important, what happens in this pre-sentence investigation is that you're going to be assigned a probation officer. And the probation officer is going to interview the defendant, and the probation officer is going to essentially be looking to either increase the amount of time that you're going to get or that the defendant would get uh, due to his conviction. The probation officer may be looking to ensure that the defendant gets the standard amount of time that any defendant would get, or the probation officer may be looking to reduce the amount of time that the defendant would get in a criminal case. Now, how is the probation officer going to determine how much time that the defendant who's been convicted would get? Well, he's going to interview the defendant, and he's going to create a pre-sentencing report, right? So then we get into the pre-sentencing report, and essentially the probation officer is going to take a deep dive on the defendant, and he's going to look into the defendant's criminal history. He's going to look into the circumstances surrounding the actual crime. He's going to look at other mitigating factors, whether or not the defendant has children, whether or not the defendant is caring for people, and things of that nature. And not to say that that is going to reduce the amount of time that the defendant would get, but the report is going to contain all this information, and he's going to the probation officer is going to make a recommendation. I mean, if you've done a heinous crime, if you murdered and killed and raped somebody, at that point, the court isn't really going to be concerned about your children and things of that nature, because they want you to be held accountable for the crime, right? But it's a big picture. It's a big picture. That's what I get from reading this. And essentially, again, we'll just go through some of this. The sentencing report must identify all applicable guidelines and policy statements of the Sentencing Commission, calculate the defendant's offense level and criminal history categories, state the resulting sentence range and kinds of sentences available, identify any factors relevant to the appropriate kind of sentence or the appropriate sentences within the applicable sentencing range, identify any basis for departing from the applicable sentencing range. And this is essentially what I'm talking about. A defendant could get more, a defendant could get less, right? It all depends on the nature of the crime, and it all depends on the it all depends on the circumstances in the defendant's life. It all depends on the circumstances that the victims are facing. It all depends, right? But the pre-sentencing report is going to contain all this information so that the defendant, in this case, can either make a case for getting less time, or the probation officer will make a case for giving the defendant more time, so on and so forth, right? So the pre-sentencing report is going to contain all that information. And then it says additional information. The pre-sentence report must also contain the following: the defendant's history and characteristics, including any prior criminal record. So this is what I was talking about. The defendant's financial condition and any circumstances affecting the defendant's behavior that may be helpful in imposing sentences or in correctional treatment. Information that assesses any financial, social, or psychological and medical impact on any victim. So this is another thing I'm talking about. They're going to be looking at the victim as well, and how all this impacts the victim. When appropriate, the nature and extent of non-prison programs and resources available to the defendant. So here's another thing that could allow a defendant to forego being locked up. So in a situation where you've lost, in a situation where the defendant has lost, the defendant still has a chance to avoid going to jail if he can identify programs and resources available to say that, hey, I committed these crimes, but, I was sick, or I committed these crimes and I'm going to participate in this program that's going to reduce or eliminate the need for me to go to jail, right? So this is a very important piece. Just because a person is considered guilty doesn't necessarily mean that they have to go to jail, because when appropriate, the nature and extent of non-prison programs and resources available to that defendant. So the defendant could walk if he participates in certain programs. Now, this option is not probably going to be available for everybody, but it could be available to some defendants. And even if you don't avoid jail totally, it could be there could be an opportunity where the defendant could participate in the program and get time reduced. So, and then it says when the law provides for restitution, information sufficient for restitution order. And this is going to be kind of important, because another section of the post-conviction procedures talks about the restitution to victims and identifying the defendant's financial assets, and it also covers a seizure portion of the post-conviction procedures, right? So if the court orders a study, I'm going to skip that statement, whether the government has seeks forfeiture under Rule 32, that's getting into the forfeiture procedures. Any other information that the court requires, including information relevant to factors under 18 U.S.C. 3553. All right, so there are some things that can't go into the pre-sentencing report, and any diagnosis that, if disclosed, might seriously disrupt rehabilitation program. Any sources of information obtained upon a promise of confidentiality, and any other information that, if disclosed, might result in physical or other harm to the defendants or others, right? So I can only speculate what all this means. Essentially, what I'm getting from this is that there are certain things you wouldn't want to put in the pre-sentencing report, because it may do damage to either the defendant, or it could do damage to the victims in this case. And obviously, you wouldn't want to put in the pre-sentencing report any information that was given up or obtained from a promise of confidentiality. Like if there was something either the defendant or the victim actually told the officers of the court under confidentiality, right? Then that information wouldn't be put into the uh, pre-sentencing report, right? So let me know what you guys think about this. If you're a lawyer and you're watching this, definitely leave your comments below and let us know if I'm off, I'm wrong, I'm on point, so on and so forth. And likewise for everyone else, let me know what you think about this video thus far. Do you think I'm making sense here? Do you think I'm wrong or right? Do you disagree with what I'm saying? It's hard to disagree with what I'm saying, because I'm just giving you facts, right? So here is the portion where it talks about disclosing a report and recommendations. And I'm just going to try to power through this, and I'm just going to say the purpose of disclosing the pre-sentencing report is to give the defendant time enough to object to what goes into the pre-sentencing report. And there are requirements where the probation officer has to provide this information in a timely manner. And we'll get into some of this. So the minimum required notice, the probation officer must give the pre-sentence report to the defendant attorney, and an attorney for the government at least 35 days before sentencing, unless the defendant waives the minimum period, right? So the defendant has to get a copy of this report, and it's important that he gets a copy of this report, because the defendant may want to object to some of the information in the report. So this is another phase of the game, which I like to call end game, because we're talking about how much time the defendant would potentially receive if he's convicted. And if the probation officer is putting nonsense into the report, the court has to take that nonsense as fact. So even though it's not true, or something is being put in a report that's not true, the court has to essentially take everything that's in that report as true. So it's important that the defendant gets a copy of this report, and it's important that the defendant reads it thoroughly, and if anything is in that report that's not true or is just presidential, then the defendant needs to uh, object to it and say, hey, that's it's prejudice, or I object. This information is not true, because this is the information that the judge is going to use to give the defendant a sentence, right? So then it goes on and it talks about sentencing recommendation by local rule, by local rule or by order in a case, the court may direct the probation officer not to disclose to anyone other than the court the officer's recommendation of the sentence. And then it talks about the objections to the report. Essentially, you have 14 days of receiving the report to object, and you also have, so you get multiple opportunities to object, but the first opportunity arises in 14 days, and then there's another opportunity that arises at least 7 days before sentencing, right? So it's important that the defendant in any federal case gets a copy of that pre-sentencing report, and it's important that the defendant gets the opportunity to object to it, right? So I'll just skim through this. Within 14 days after receiving the pre-sentencing report, the parties must state in writing any objections, right? And of course, the prosecutors have the opportunity to object to the report as well, because the prosecutors may want the defendant to get more time, but the defendant may have gotten less time, so the prosecutors have an opportunity to object to that, right? And then it says serving objections. Any objecting party must provide a copy of the objections to the opposing party and to the probation officers. And then actions on objections. After receiving the objections, and probation officer may meet with the parties to discuss the objections. The probation officer may then investigate further and revise the pre-sentencing report as appropriate, right? So to me, it looks like this is yet another opportunity to clear up the pre-sentencing report. So if the defendant objects to things that are in the report, then by law, the probation officer must meet with the defendant and the prosecutors to basically discuss this information. And then from there, the probation officer is going to do a further investigation. And then submitting the report at least 7 days before sentencing, the probation officer must submit to the court and to the parties the pre-sentence report and the addendum containing any unresolved objections, the grounds for those objections, and the probation officer's comments on them, right? So if after meeting with the defendant and the prosecutors, the objections are not resolved, then of course it looks like the probation officer submits the report to the court anyway. However, there's going to be notes for the objections, and there's going to be the probation officer's notes on those objections, right? Then it goes on, it says notice of possible departure from sentencing guidelines. And this is where I was talking about earlier, where I said that even though a defendant loses, he gets convicted in federal court, there is still an opportunity to receive less time. And conversely, there's an opportunity for the defendant to receive more time, right? So before any court may depart from the applicable sentencing range on the ground not identified before the departure, either in the pre-sentence report or in the party's pre-hearing submission, the court must give the parties reasonable notice that it is contemplating such a departure. The notice must specify any ground which the court is contemplating a departure. So I guess the court has to give the parties notice that they're going to either give the defendant less time or more time. In general, at sentencing, the court must verify the defendant and the defendant's attorney have read and discussed the pre-sentence report, and the addendum to the report must give to the defendant and an attorney for the government a written summary of the summarized in the camera or any information excluded from the pre-sentence report, and must allow the parties and attorneys to comment on the probation officer's determinations and other matters relating to the appropriate sentences. So again, yet again, this is another opportunity for the parties and the defendant to essentially comment on any departure from the the guidelines for sentencing. If the defendant is going to get more time, this is an opportunity to speak on that and try to prevent that from happening. And conversely, if the defendant is going to get less time, this is the perfect time for the defendant to speak to the court to try to get less time. I'm sorry, this is the perfect time for the prosecutors to speak to the court to try to keep the defendant from getting less time. And then it goes on for may for good cause allow a party to make a new objection at any time before sentencing is imposed. So again, there are multiple opportunities for a defendant to object to the pre-sentencing report, which is going to effectively be the tool used to decide how much time the defendant is going to use. So that's why I think it's important, though, even though a defendant has lost, even though a defendant has been convicted, it's important to essentially try to object and try to participate in the end game, because the end game is just important as any other phase of the game. You know, it's more important than the beginning of the litigation, more important than the middle of the litigation, and just as important as any other phase of the litigation, because we're looking at possibly just asking for a new trial. We're looking at possibly asking to appeal, or we're just possibly looking to reduce the amount of time that's going to be dished out. There's a lot that goes on here, and therefore the post-conviction procedure, aka the end game, is very important. And it talks about introducing evidence, producing a statement. The court may permit the parties to introduce evidence on the objections if a witness testifies at sentencing. And F, if applies, if a party fails to comply with Rule 26.2, order to produce a witness statement, the court must not consider the witness's testimony. And then it goes on and says, court determinations, at sentencing, the court may accept the undisputed portion of the pre-sentence report as a finding of fact. So this is what I was trying to say. Like, just because a defendant has lost, it's in that defendant's best interest to continue fighting, because what can happen is that things can go into the pre-sentencing report that's going to essentially force that defendant to do more time. So if inaccurate information is put into that pre-sentence report, then that inaccurate information is going to be accepted as fact, right? You know, may accept any undisputed portion of the pre-sentence report as a finding of fact, right? You know, so the end game is important. You want to make sure that, well, the defendant wants to make sure that the information going into that report does not hurt him unfairly, right? The information going into that report should be information that go into the report, and it's presented in a way that it doesn't shed false light, if you will, on the defendant, right? So must, for any dispute or portion of the pre-sentence report or other controverted matter, rule on the dispute or determine that the ruling is unnecessary, either because the matter will not affect sentencing or because a court will not consider the matter in sentencing. So the objections that the defendant brings up in the pre-sentence report, the court must rule on those objections. So again, I can't stress it enough. Just because a defendant has lost in federal criminal court, it's not over. There is still quite a bit of fight left, because the defendant can potentially get less time, and must append a copy of the court's determinations under this rule to a copy of the pre-sentence report made available to the Bureau of Prisons, right? So all the documentation gets handed over for the Bureau of Prison, and I'm pretty sure, I would imagine, that there's some process and procedures where the Bureau of Prisons uses this information to essentially manage the defendant. That's my observation. That's what I deduce. I'm not sure if that's true, right? And then it says opportunity to speak by a party before imposing sentence, the court must. And I'm just going to skip this because you've seen this. This is where the defendant comes out and the defendant tries to speak to try to reduce his sentence. And the witnesses comes out and they speak either in support of the defendant or they speak either to increase the defendant's prison sentence. So you've seen this, right? I have seen situations where victims will come out and they'll speak on behalf of the defendant so that the defendant can get less time. And it really just all depends on the situation, exactly what happens. But more than likely, witnesses and victims will be coming out to speak to find ways to get the judge to increase the defendant's time. And then anyone else impacted by the crime, they may not be a victim. I guess they would still be a victim. For example, if a mother lost her child because of a crime committed by the defendant, then that mother would be a victim and that mother would get a chance to speak, right? Um, let's see here. Defendant's right to appeal. Okay, so appealing a conviction. If the defendant pleaded not guilty and was convicted after sentencing, the court must advise the defendant of the right to appeal the conviction. And then appealing the sentence. After sentencing, regardless of the defendant's plea, the court must advise the defendant of any right to appeal the sentence and appeal costs. Essentially, this basically gives the defendant the right to file for a status called forma pauperis, which basically means you're poor and you have no money, right? So these are other things that the defendant would want to pay attention to. The defendant may want to appeal his conviction, or he may want to appeal his sentence, which is going to be, it's going to include using the pre-sentencing report to say that they did this wrong, they did that wrong, so on and so forth. And judgment. In general, the judgment of conviction, the court must set forth the plea, the jury verdict, or the court's findings, the adjudication, and the sentence. If the defendant is found not guilty or is otherwise entitled to be discharged, the court must so order, the judge must sign the judgment, and the clerk must enter it. Now, here forfeiture is mentioned. Forfeiture proceedings are governed by Rule 32.2, but it's just kind of funny how it just mentions it here because it doesn't discuss it further in this section. It's discussed much later, but just giving you a sneak peek. A defendant may have assets. Perhaps the defendants use his assets to actually commit crimes. So in that situation, the government is going to seize that defendant's assets. Or there could be a situation where the defendant has gained assets through his crimes. And of course, in that situation, the government is going to be looking to seize assets, right? Or there just could simply be a situation where the defendant needs to compensate his victims and the defendant has assets, then the court in that situation is going to be looking to seize the defendant's assets to make restitution to the victims at that point. So now we get into something which I'm actually just going to speed through really quickly because I'm just kind of puzzled as to why it's here, but basically they talk about revoking or modifying probation or supervised release. And essentially there could be a situation where a defendant was found guilty and the defendant was given probation and released on probation, and the defendant violated his probation, and as a result of that, the defendant is being locked up because of violating his probation. That's the gist of it. I'm just going to sum this whole section up with that. And of course, there's going to be a situation where the defendant appears in a district with jurisdiction. Then in that situation, the court can just go ahead and proceed with the process of basically locking the defendant up for the violations or making any other decisions that may release the defendant back out on probation with stipulations. or in the event that the defendant is in a court lacking jurisdiction, then what's going to happen, that court is going to go through the process of transferring the defendant to the court of proper jurisdiction so that they can continue the process of figuring out what to do because of the violation of his probation or temporary release. That's how we're going to sum that section up. We're just going to move on. Okay, so we're going to skip over on to forfeiture, right? So notice to the defendant, a court must not enter a judgment or forfeiture in a criminal procedure unless the indictment or information contains notice to the defendants that the government will seek the forfeiture of property as part of any sentence in accordance with the applicable statute. So this is pretty important. As I said earlier, if the defendant has assets that the government wants to take, then those assets will have to be listed, not listed, I'm sorry. The prosecutors have to note that in their indictment that they intend to seize assets, right? And then it says notice should not be designated as a count of the indictment or information. The indictment or information need not identify the property subject to forfeiture or specify the amount of any forfeiture money judgment that the government seeks, right? So for the most part, they just have to say the defendant committed these crimes, and according to this statute, we have a right to go after his assets, right? So entering a preliminary order for forfeiture, and this is called the forfeiture phase of the trial, right? In the post conviction procedures, they're going to be looking to forfeit the assets of the defendant as appropriate to the statutes, right? So basically, as soon as practical, or after verdict or finding of guilty, or after plea of guilty, or nolo contender is accepted, on any account or any indictment or information regarding which criminal forfeiture is sought, the court must determine what property is subject to forfeiture and under the applicable statute. So the property and the assets of the defendant is identified in the forfeiture phase. So when the government indicts the defendant, they don't necessarily have to say, oh, well, he has, this house, he has this car, he has this bank account, and all these assets are the result of his crime, and we want to forfeit you. We want to forfeit those items. The government doesn't have to do that. They just have to cite the applicable statute, and they just have to say that they're looking to seek to seize, the assets from the crime, or they're looking to seize assets for whatever reasons, right? And it goes on to say, if the government seeks forfeiture of a specific property, the court must determine whether the government has established the requisite nexus between the property and the offense. If the government seeks a personal money judgment, the court must determine the amount of money that defendant will be ordered to pay. Right? So in this phase of the trial, the prosecutors have to basically dot the lines, or they have to paint the lines from the defendant's crime and the assets that the defendant has, right? So there could be a situation, like I said earlier, where the defendant used his money that he got that essentially didn't have anything to do with the crime in the beginning. But, since he has all this money, he has all these assets, then the government is going to be looking to take those assets because those assets was used to help the defendant violate or, basically violate the victim or commit the crime. So that's what that's about. And of course, if the defendant gained assets after the commission of the crime, then the defendant is going to lose that property. And then thirdly, if there's a money judgment for damage done to the victims, then the prosecutors are going to be looking to get a money judgment against the defendant and then identify the assets of the defendant so they can take it. So long story though, they're going to take your stuff if you commit a crime. and you have stuff to take. That's the long story, long and the short of it, right? So, evidence of hearing, and basically they're going to be looking to hear the evidence of how these assets were involved or related to the crime, and they're asking the judge to basically put a judgment in because of it. And preliminary order. So basically, the judge is going to put an order in to say that, these are the assets of the defendant, and these assets should be seized for whatever reason. But I better actually read this because it's actually tricky, because they are not necessarily allowed to take the assets right away. So if the court finds that the property is subject to forfeiture, it must promptly enter a preliminary order for forfeiture. Preliminary basically means that, the order is kind of initial order, is not final, right? Setting forth the amount of any money judgment, directing the forfeiture of a specific property, and directing the forfeiture of any substitute property if the government has met the statutory criteria. And then it goes, a court must enter the order without regard to any third party's interest. And this is actually going to be pretty interesting, because a third party could have an interest in the property that the government or the court is about to seize, right? And we're going to get into that in a minute, right? So without regard to any third party interest in the property. So the court is issuing the preliminary order, and they don't really pay attention to who else co-owns the property. And that's why this is preliminary, because what's going to happen, as you'll see later, the third party has the right to come in and say, hey, wait a minute, he doesn't own that property outright. This property is only partly his, right? So, and then it goes on, determining whether a third party has such an interest must be deferred until any third party files a claim in an ancillary proceeding under Rule 32.2c. So if they're about to take, so let's say you own a property, right? A multi-unit property. Let's say it's a 15 unit, and you own it, you co-own it with the defendant. And let's say that without your knowledge, the defendant, and I'm making this all up as I go along, so I mean, work with me here, right? So let's say the defendant, without your knowledge, was using this property as a means to essentially commit illegal crimes. We're not going to get into what this is, what crimes he committed. So now they're looking to seize this property, and you find out about this whole case, and you're like, wait a minute. This is my property. I had nothing to do with what he was doing with the property, and I didn't know about, this case, and I'm just finding out now because they put a seizure notice on my property, right? So now you have to file what they call a ancillary claim to basically try to hold on to your property, right? Then it talks about timing. Unless doing so is impractical, the court must enter a preliminary order sufficient in advance of sentencing to allow the parties to suggest revisions or modifications before the order becomes final as to the defendant. And then it goes, general order, if before sentencing the court cannot identify all specific properties subject to forfeiture or calculate the total amount of money judgment, the court may enter a forfeiture order that lists any identified property, describes other property in general terms, and states in that the order will be amended according to the rules when additional specific property is identified or the amount of money judgment has been calculated, right? So the preliminary order is just a general order saying, yeah, we're going to take your stuff. We don't know exactly what we're going to take, but here's the things that we think that you have. We're definitely going to take that, and we're going to take additional stuff as we go through all your stuff and see what you have and calculate the amount of money you owe. We'll give you a final bill later, but for now, this is what we're going to take, right? And then it talks about seizing the property, right? Seizing property. The entry of a preliminary order or forfeiture authorizes the Attorney General or designee to seize the specific property subject to forfeiture to conduct any discovery the court considers proper in identifying, locating, or disposing of property, and to commence proceedings that comply with the statutes governing the third-party rights, right? So they're going to be looking to seize it, but they have to comply with third-party rights. Again, if you have a property that you have with a co-defendant, then you have to right away get a lawyer or go pro se if you're brave and go to federal court and file a motion to initiate the ancillary proceedings to save your property, right? And then it goes on sentencing and judgment. When final, the sentencing or at any time before the sentence, if the defendant consents to the preliminary for forfeiture order becomes final as to the defendant. So the defendant can at this point say, hey, you know what? I'm just going to go ahead and give that property to you. You can have it, right? He can just waive this section. But again, this is going to be important, an important phase of the post-conviction procedures, also known as endgame, because the defendant could have, the defendant can be a millionaire, right? And if the defendant is a millionaire, he does not want his property taken by the government because one thing, he may need that property to further fight his case, right? So let's say you have a defendant has over $20 million, right? And then the government is looking to seize that complete $20 million as a result of his crime. Well, if that happens, how does the defendant pay for his legal needs at that point, right? How does the defendant pay for an appeal, right? You just read where they'll appoint an appeals lawyer to you if you don't have any money. But you may not want the lawyer that they're going to appeal because maybe they're going to assign you a crappy lawyer, right? The court could assign you a crappy lawyer. You want the lawyer that the $20 million is going to get you, and not the lawyer that the court is going to assign. Just my 2 cents there, right? So the end game or the post-conviction procedures is extremely important when it comes down to your property. Now, of course, if you don't have any property and you don't have anything of value, then of course you're going to waive any judgments that they want to put in against you. I think sometimes they still try to put monetary judgments again against you, even though you may not have anything. And I think the reason for that is that if for whatever situation you find yourself out of prison and you find yourself making money again, then that judgment is still going to stand. They're going to be looking to come back and get that money, right? So notice an inclusion of judgment. The court must include the forfeiture when orally announced and the sentence or must otherwise ensure the defendant knows of the forfeiture as sentencing. And then time to appeal. The time for the defendant or the government to file an appeal from the forfeiture order or from the court's failure to enter an order begins to run when the judgment is entered. If the court later amends or declines to amend the forfeiture order to include additional property under Rule 32.2e, the defendant or the government may file an appeal regarding the property under federal rules of appellate procedure. So basically, there's nothing special about this. It's just saying that if the defendant is having property taken away from him, he can appeal it. And if the government is finding that no property is being taken or not enough property is being taken, then they can appeal it. All right, so jury determination. Basically, long story dull, a jury typically isn't involved, I think. Let's see, retaining the jury. In any case tried before a jury, if the indictment or information states that the government is seeking a forfeiture, the court must determine before jury begins deliberating whether either party requests that a jury be retained to determine forfeitability of the specified property if it returns a guilty verdict. This is probably going to be a departure from the 2014 version, because I think the 2014 version basically says that a jury is not, there is no right for a trial by jury, but the court can still grant one. And here it just says, if a jury is actually put together, right? So this is interesting because here you can have another jury trial to determine whether or not your property should be taken if you're a defendant, right? And they have to put it on some special form. If a party timely requests to have the jury to determine forfeiture, the government must submit a proposal special verdict form listing each property subject to forfeiture and asking the jury to determine whether the government has established the requisite nexus between the property and the offense committed by the defendant. So when it says requisite nexus, basically they're saying that the government has to prove that there's a link between this property and a crime. And notice of forfeiture order, publishing and sending notice. If the court orders that the forfeiture of a specific property, government must publish notice of the order and sending notice to any persons who reasonably appears to be a potential claimant with the standing to contest a forfeiture in an ancillary proceeding, right? So this is where they notify third parties or any other party that has an interest in the property they're about to seize. Content of the notice, we don't need to go through that. Means of publications, we'll skip that. Means of sending notice, we'll skip that. And interlocutory sale. At any time before entry of a final forfeiture order, the court, in accordance with the supplemental rule G7 of the Federal Rules of Civil Procedure, may order the interlocutory sale of property alleged in a to be forfeitable. Did I say that right? Yeah. Any property that they can actually seize, right? So essentially interlocutory means that while the defendant or third party has a right to appeal this, they're still going to proceed with the sale of the property, right? And interlocutory typically means that we're going to, there could be a major issue that the defendant disagrees with in the trial, and the defendant wants to appeal that decision. So they're going to allow the defendant to appeal that decision, but they're still going to move on with the trial. Typically, anytime you appeal something, the court loses jurisdiction, the lower court. So let's say there's an example where the defendant wants to appeal his verdict or his judgment, and they're going to allow the defendant to appeal it, but they're still going to move forward with the sale of the property, right? If the conditions are met under the supplemental rule G7. I don't know what that is. If you're interested, I can go and look that up. Comments below. But essentially, all this means is they're going to allow the defendant to appeal, and then they're still going to go ahead with the sale, or the third party to appeal, and they're going to go ahead with the sale, right? Ancillary proceedings, entering a final order of forfeiture. In general, if prescribed by a statute, a third party files a petition asserting an interest in the property to be forfeited, the court must conduct an ancillary proceeding, but no ancillary proceeding is required to the extent that the forfeiture consists of a money judgment. So in the ancillary proceedings, the court may, on motion, dismiss the petition for lack of standing, for failure to state a claim, or for any other lawful reason. For the purpose of the motion, the facts set forth the petition are assumed to be true, right? So long story though, they're just saying that the third party can file a motion to basically preserve his property, but that motion can be dismissed because you don't have a right to go to court over the matter, right? You could be a third party, but let's say you don't rightfully own that property, so they can dismiss it for lack of standing, right? If you're a third party, you're coming in and you're trying to actually prevent the sale of the defendant's property, but you're not on the title and the property is not promised to you by the defendant, then it could be dismissed for lack of standing. And failure to state a claim. This essentially means that there's no facts that match up to any statute or law that would allow you to be granted relief, right? So you can go in and saying, hey, this one is a bit complicated, but basically failure to state a claim, you typically see this in pro se lawsuits when people go to court and they try to sue someone, but they don't provide the appropriate facts, or they don't provide a law or statute that's going to be able to grant them relief. So you can go in, you can provide all the facts, but you don't provide the statute or law that says that you should get relief. That's going to be failure to state a claim. That's it in a nutshell. Then over any other lawful reason. So just because you're a third party doesn't mean, and now to me, I believe in truth and I believe in you know, honesty and all that good stuff. And I would think that it doesn't matter if you're able to artfully write out a lawsuit, which is going to be dismissed before failure to state a claim, regardless of any of that. If the property is yours or you're a co-owner, I believe you should, be granted relief, right? So that's my thinking. But court is a game. So if you don't file the petition correctly and you don't put in the correct laws, you don't have the correct wording, they'll dismiss your stuff and leave you hanging, right? So anyway, after disposing of any motion filed under Rule 32.2C, I don't even like the way they worded that. After disposing of any motion, how about after the result of any motion, or after the judgment, after a judgment is issued on any motion? Then under the final Rule 32.2, I don't like the way they read that, because to me, when you dispose of something, it has a negative connotation, right? You're throwing it in the garbage or you're throwing it in the trash heap, So to me, it seems like this thing is written I don't know, I just don't like the way it's written, because it implies that the third party's motion to preserve his property is going to be disposed of. I don't like that way it sounds. Anyway, I'm going off on a tangent. So after disposing of any motion filed under Rule 32.2C and before conducting a hearing on the petition, the court may permit the parties to conduct discovery in accordance with the Federal Rules of Civil Procedure if the court determines that discovery is necessary or desirable to resolve factual issues. When discovery ends, a party may move for a summary judgment under Federal Rule of Civil Procedure 56. Entering a final order when the ancillary proceeding ends, the court must enter a final order of forfeiture by amending the preliminary order as necessary to account for any third-party rights. If no third party files a timely petition, the preliminary order becomes a final order of forfeiture if the court finds that the defendant or any other combination of defendants convicted in the case had an interest in the property that is forfeitable under the applicable statute. The defendant may not object to the entry of the final order on the grounds that the property belongs in whole and part to a co-defendant or third party, nor may a third party object to the final order on the grounds that the third party had an interest in the property. Yeah, so if no third party files a timely petition, so if you don't file in time, then they're just going to seize it. Long story dull. If the defendant doesn't say anything in time and if the third party doesn't come forth in time, they're going to seize it. Multiple petitions. If multiple third party petitions are filed in the same case, an order dismissing or granting one petition is not appealable until rulings are made on all petitions. So if multiple people come forward, then they have to make a judgment that's going to dispose of all the litigants' petitions. So let's say in that scenario I gave earlier, let's say the defendant owned the property with, let's say, 8 other people, right? The multi-unit property. So they have to deal with the claims of all the 8 people, and including the defendant, before they can issue a final order. Ancillary proceeding is not part of the sentencing, and ancillary proceeding is not part of sentencing. Okay, stay pending appeal. If a defendant appeals from a conviction or an order of forfeiture, the court may stay the order for forfeiture on terms appropriate to ensure the property remains available pending appellate review. And this is what I was talking about earlier. If they seize the defendant's property, the defendant has a right to appeal that seizure, and the defendant can ask that nothing be taken or nothing be sold until this is appealed, and there's a final decision on the appeals court decision. So now there could be a situation where the judge just simply says no and seizes the property anyway. So in that situation, there's going to be that interlocutory sale of the property, as we read about earlier. And then it talks about subsequently locating properties. Subsequently located property, substitute property, right? And in general, on the government's motion, the court may at time enter an order for forfeiture or amend an existing order of forfeiture to include property that is subject to forfeiture under the existing order, or forfeiture but was not located and identified after the order was entered, right? So basically they issued an order at a later date saying they couldn't find this property, and they now found it and they want to take it, or they didn't realize that this property was available to be forfeited. So here they would be able to basically amend the order and come back and take the property. Jury trial limited. So this is what I was talking about earlier. There's no right to a jury trial under Rule 32.2E. All right, so now we get into, wow, this is really, the clock is really ticking on this. It's been going at this almost an hour now. So anyway, so we're going to get into, maybe I'll split this video up. I don't know, or maybe I'll just keep it one big video. I hate videos like this because information can be boring at times, and I'm not really good at making information exciting. So I'll make a decision on whether or not I'll split it up. I'll probably, me being lazy, I'll just put it in one big video. So Rule 33, we get into some of the other options in the post-conviction proceedings, also known as the end game. And this is yet another reason a defendant may not want to give up. The defendant may want to fight harder, and the defendant may want to essentially stay in the game, even though they have a judgment against them in a criminal proceeding in federal court, right? So the defendant can seek a new trial, right? Defendant's motion, the court may vacate any judgment and grant a new trial if the interest of justice so requires. If the case was tried without a jury, the court may take additional testimony and enter a new judgment. So a defendant, even though you've been found guilty, is not over. You can have a new trial, right? You just have to request it, and you have to present convincing evidence, right? Now, we get into the time period, right? Time to file newly discovered evidence, right? Any motion for a new trial grounded on newly discovered evidence must be filed within 3 years after the verdict or finding of guilty. If an appeal is pending, the court may not grant a motion for a new trial until the appeals court remands the case. So whenever a defendant or anybody appeals a case, and this is kind of a general rule, that case the court that issued the judgment lose jurisdiction, and now the appeals court is given jurisdiction, so nothing else can happen in the lower court while it's in appellate court. So other grounds, any motion for a new trial grounded on any other reason other than newly discovered evidence must be filed within 14 days after the verdict of finding guilty. So basically, it's tricky, and this is why the defendant needs to pay attention, because the defendant only has 14 days to ask for a new trial, and subsequently the defendant only has, and this is just going to be a spoiler because we're going to read it soon, but the defendant only has 14 days to file an appeal. So there's a very small time window at which a defendant can appeal, right? Or ask for a new trial. And I just find this funny. I'm not sure why this is different, because in a civil case, you have 30 days. So I'm not sure why there's a difference between a civil and criminal case. I would imagine that they would grant more time in a criminal case, because you're talking about someone's life. You're going to lock them up for 30 years to life or whatever. I would imagine you give them more time to file an appeal, like maybe 90 days or something, right? But You read it. I mean, you can see you only have 14 days to appeal a criminal conviction in federal court, and that's just kind of crazy, right? So, and then it goes Rule 34, and I think we're done here. Are we done? Are we done? Rule 34, arresting judgment in general upon the defendant's motion or his own or on its own, the court must arrest judgment if the court does not have jurisdiction of the charged offense. So if for whatever reason the court didn't have jurisdiction, then the court is going to have to stop whatever it's doing, right? Then it talks about the time to file. The defendant must move to arrest judgment within 14 days after the court accepts a verdict or finding of guilty or after guilty plea or nolo contendere. Honestly, this is kind of slippery because if a court doesn't have jurisdiction, then you can challenge that court at any time. It doesn't matter. So I'm not understanding why they're saying 14 days. This is a well-known thing. If a court does not have jurisdiction and they enter a judgment, you can come back 10 days from now, you can come back 10 years from now, you can come back 30 years from now, and you can move to have that judgment vacated. So correcting clear error within 14 days after sentencing, the court may correct a sentence that resulted in an arithmetical or technical or other clear error. Reducing sentence for substantial assistance. In general, upon the government's motion within 1 year of sentence, the court may reduce the sentence if the defendant, after sentence, provides substantial assistance and investigation or prosecuted another person. So this is the section that's basically going to help snitches. You know, they say snitches get stitches, but snitches get released, right? So there are situations where the person is convicted and may be sentenced for a very long time, could be life, but if that individual has information that's going to help the government solve a bigger crime, then you just read right there that the government can reduce or even eliminate that person's sentence, right? Later motion. Upon the government's motion made more than 1 year after sentencing, the court may reduce the sentence if the defendant substantial assistance involved information. And this basically, I mean, you get the gist of it. If you help with the government's case, they can reduce your sentence. So we're just going to skip that. Or they can file a motion to the judge to reduce your sentence. Evaluating substantial assistance, we're going to skip that. Below statutory minimum. When acting under Rule 35B, the court may reduce the sentence to a level below the minimum sentence established by statute. Then it talks about clerical error. After giving a notice it considers appropriate, the court may at time correct a clerical error in the judgment. Moving on. Indicative ruling or motion for relief that is barred by pending appeal. Relief pending appeal. If a timely motion is made for relief that the court lacks authority to grant because of an appeal that has been docketed and is pending, the court may defer consideration of the motion, deny the motion, state either that it would grant the motion if the Court of Appeals remands for the purpose or the motion raises a substantial issue. So even though the court doesn't have jurisdiction, they can do these things to try to grant some relief, right? They can say, we're going to defer this until it comes back to the court after the appeal. They can deny the motion saying that they don't have jurisdiction, or they can indicate that maybe we will grant relief, but we can't because the case is currently in the appeals court. Notice to the Court of Appeals, the movement must promptly notify the circuit court. The movement must promptly notify the circuit clerk under the Federal Rules of Appellate Procedure 12.1 if the district court states that it would grant the motion or that the motion raises a substantial issue. And then it talks about remand. The district court may decide the motion if the court of appeals remands for that purpose. And then this thing goes on. I was hoping, wow, it feels like they somehow made this section longer because it didn't seem like it took me an hour to go through this stuff before. So anyway, so staying, Rule 38, staying a sentence or disability. So I'm going to speed through this, and I'm just going to say that you can have your conviction stayed until the results comes back from appeal, right? Um, Imprisonment. Okay, actually, I think we better go through this because it's kind of important. The court must stay the death sentence if the defendant appeals the convictions or sentence. And then when we talk about imprisonment, stay granted. If the defendant is released pending appeal, the court must stay the sentence of imprisonment, right? So if you've lost but you want to appeal, there's a chance that you can not go to jail until the appellate court comes back and basically makes a decision. And stay denied, place of confinement. If the defendant is not released pending appeal, the court may recommend to the Attorney General that the defendant be confined near the place of the trial or appeal for a period reasonably necessary to permit the defendant to assist in preparing the appeal, right? You could be given probation. If the defendant appeals, the court may stay a sentence of probation. The court must set the terms of any stay. Restitution and notice to victims. We'll skip this. I think we are pretty much done here. So there you have it, folks. This is it. This is an overview of the post-conviction procedures. And you can clearly see just because a defendant has been convicted or found guilty of a crime in federal court, his fight or her fight is not over. There's lots of stuff that a defendant will want to pay attention to in this event. And this is the end game. This is where the defendant gets a chance to reduce his sentence. This is a chance where the defendant gets to fight for any property that the government is trying to seize. This is the phase where third parties can come in and try to fight for property that the government is trying to seize. This is also the phase where the defendant can ask for a new trial or try to vacate the judgment. This is also the phase where the defendant can try to appeal the decision made against them. So that's it for this video. Thanks for watching. Leave your questions and comments below. Let me know what you thought. Please like, share, and subscribe.